This leads our bulletin. Former President Jacob Zuma is now able to appeal a ruling on his medical parole. In his original judgment, Judge Elias Matojane ordered Zuma return to jail to complete his 15-month sentence for contempt of court. He was released on medical parole by former prison's boss Fraser just 2 months into his sentence. Maseko Ratlacha is following proceedings for us. She joins us now live in studio. So we obviously know that Zuma can appeal. Take us through what should be noted from today's ruling, though.
Well, Shahan, you might remember that with Judge Elias Matojane last week, in fact, in the North Gauteng High Court, that's the High Court in Pretoria. Initially, he didn't say much about the former president's age and whether or not he, deserves some compassion and empathy because of his age and his ailing, health. But this time around, and a lot of people, Shahan, would ask, for instance, if we are surprised by today's ruling for the former president to be given the permission to appeal that judgment from last week. I wasn't surprised, Shahan, because in the beginning, as Advocate Dalim Bofu for the former president was, making his arguments heard, Judge Elias Matojane actually went on to talk about that particular fact. He was suddenly asking the advocate about the former president's age and the fact that, that could have been considered in terms of the fact that he has an ailing health. His health is ailing. So that was what made it obvious that the judge would actually give them or grant them permission to go and appeal at the Supreme Court of Appeal. So that's the number one thing that was a big taking from the ruling from today. But also, Shahan, the fact that he was talking about the fact that the former president did not grant himself parole. He was talking about the fact that he cannot be punished for the decision that was taken by Fraser. All he did was apply for medical parole. But to say that he needs to start serving his sentence again, from where he had left it off. Because remember, he did say last week that once he does go back to prison, he cannot, suddenly say that the couple of weeks that he's been out should be counted as part of that 15-month jail term. But now today, the judge saying that, because the former president didn't grant himself that parole, he simply just asked for it. So it's not his fault that it was granted. But let's take a listen to the judge himself as he was making that ruling earlier today.
In my view, this matter merits the Supreme Court of Appeal's attention to bring certainty in the correct interpretation and application of these provisions. I'm also of the view that there is a reasonable possibility that another court may find that the order that the third respondent's time spent on medical parole should not count towards fulfilling his sentence, as this impacts on him unfairly in that, one, it was not his decision but that of the commissioner to be released on medical parole. Second, his meeting with his political allies and a prayer meeting was a once-off thing. His freedom of movement is restricted, and this has an impact on his dignity. He is serving his sentence, albeit outside prison. Third, because his illness and advanced age, what I want to say is because of his illness and advanced age, he needs compassion, he needs empathy and humaneness, which is the essence of Ubuntu. In my view, another court may take this into consideration and come to a different finding. Accordingly, for the above reason, leave to appeal is granted to the Supreme Court of Appeal, and that cost will be cost in the appeal. Court adjourns. You are all excused.
It's very important to point out that this is the application for leave to appeal that's been granted. The appeal process still has to go ahead. But what did the president and the former president, I should say, his legal team say about the wording of being terminally ill? That's a sticking point for them, isn't it?
It was, because remember, the former president's legal team, what they really wanted to harbour on, Shahan, and you saw that today during court proceedings, along with what the Correctional Services legal representative also did, was that they wanted to intentionally show the judge that he erred in his decision last week by not looking at the fact that there were doctors who in fact did say that the former president was terminally ill. So you know how lawyers are, Shahan. There's wording that they don't agree on. So, for instance, the judge in his judgment at some point said that one of the doctors said the former president was terminally ill when he did not use the word incapacitated. But of course, Advocate Dalimpofu saying that, you know, it's not up to lawyers to say whether ill and incapacitated.
Such a horrible word, I know, right? Because I actually removed it from one of my scripts today because I just hate that word.
I almost want to say incarcerated every time I want to say the word. Incapacitated. He was saying that what if the words can be used interchangeably by health officials? So you cannot, as a judge and as a lawyer, say that that word cannot be used interchangeably with the word terminally ill, right? So that was the first thing. But I just want to go back to that Correctional Services Act, Shahan. If you could just, give me some time to read it for you. It's not very long. It says that the Act of Medical Parole can only be granted to an offender suffering from a terminal illness or condition, or if such an offender is rendered physically incapacitated as a result of injury, disease, or being severely limited in terms of his movement. So remember, the board, the Medical Parole Advisory Board, looked at this act and they made the decision that they wouldn't sign off on the former president going back home. But of course, then this is when the pedantic language used by lawyers was very confusing. So there's a Section 75 and a Section 79 when it comes to parole being granted to an inmate. So Section 75 gives provision for somebody like Arthur Fraser, for instance, to make the decision and overrule anybody else because of the fact that the person we're talking about here was sentenced to less than 24 months. So that's what gives him provision in Section 75. But now they were saying, the organizations that were opposing this application to appeal or for leave to appeal were saying that the former president made the application under Section 79, which doesn't really give provision for any other person except the parole board to make that decision. But of course, Advocate Dalimpofu coming in and saying we used both acts actually to apply for that application for parole for the former president. So there was all of that argument as well. But what was important, I think, Shahan, that was also agreed upon by the judge in terms of the former president's legal team's argument today was that they were saying in the same judgment, right? The judge on paragraph 29, I think it was, stipulates a certain Dr. Mafu and what he said about the president's illness, that he went into detail, he used the exact words that I mentioned from the Correctional Services Act, and using the word incapacitated and terminally ill. Then suddenly later in the judgment, same judgment, on paragraph 62, he says he didn't get information from all the doctors. So Advocate Dalimpofu coming in and saying, so which one is it, Judge? With all due respect, in the beginning of your judgment, you say you got all the information from a certain doctor. And then suddenly, towards the end of the same judgment, you say none of the doctors actually gave you much information. But you say in the beginning that one of them did. But here's Advocate Dalimpofu, who represents the former president on that particular matter.
Even if you look at literally, your Lordship says that, let's look at paragraph 29 of your Lordship's judgment. Your Lordship says, on the same day, 20 days after the third respondent was taken into custody, Dr. Mafa applied for medical parole on behalf of the third respondent. In the application, says your Lordship, Dr. Mafa stated that the third respondent was suffering from a terminal disease or condition that is chronic and progressive. This is your Lordship speaking. He says Dr. Mafa stated that the third respondent, Mr. Zuma, was suffering from a terminal disease or condition that is chronic or progressive. Those words are taken directly from Section 79. In other words, Dr. Mafa said that he is suffering from a terminal illness. However, yourself, the same judge at paragraph 62 says, Dr. Mafa, in completing the medical parole application, does not state that the third respondent suffers from a terminal disease or condition. So where are we? Does Dr. Mafa state that he suffers from a terminal condition, as your lordship correctly points out in paragraph 29, or does not, as your lordship, the same person says at paragraph 62?
And obviously we know that the Correctional Services Department also wants to appeal that decision, so they agree.
Definitely, they agree, Shahan. They made it clear that they didn't find that their former boss, Arthur Fraser, erred in his decision to grant medical parole. In fact, they told the judge also saying that, you know, with all due respect, you did not consider the fact that we have other medical records that are with us as correctional services. You didn't even ask for these medical records, and therefore you made a decision without having all the information before you. And all you used was the limited information you had, as well as the application by the former president when he applied for medical parole. Here is Advocate Mpahlele, who represents the Department of Correctional Services.
Without interrogating all the necessary information that was before the National Commissioner when the National Commissioner made the decision on whether to grant medical parole or not. And the Lordship was not even in possession of all that information, because there was some information that is with the South African Medical Health Services that was not before the National Commissioner. I mean, that was not before this Honorable Court. And the report, some of the reports were redacted. That was before the Honorable Court. And on that basis, the Honorable Court was not in a position to make an informed decision based on all the medical evidence that was before it, and was not even in a position to interrogate those, because it didn't have them before itself. So therefore, the decision to substitute the decision of the National Commissioner with its own decision, we submitted this. It is a misdirection, my lord.
Yes, but Mr. Mpahlele, the Parole Advisory Board has all the reports, even unredacted reports, and it came to a conclusion that the third respondent does not meet.
All right, we're going to leave it right there.